Okay, so today we are going to start with family medicine. Okay, and sorry, ethics. We did family medicine last week, and today we're going to start with ethics. There is some basic concepts about ethics which you all should know. If you know the concepts, then you can solve any sort of questions they give you. If you don't know the concept, if you don't know the main points, then it will be difficult for you. So first of all, you should know it. These, like, what is the federal government, provincial government, they can give you an MCQ about it. That, okay, what does come under a federal government? So just know that under the federal government, and federal government is always superior than the provincial government. So what includes federal government is healthcare services for the indigenous, then immigrants, civil aviation personnel, all the healthcare comes under the federal government. Also for the marine hospitals, quarantine, investigations into the public health, regulation of food and drugs, then a healthcare insurance administration, inspection of the medical devices, whether they are working properly or not. Along with that, what is the provincial government? Under the provincial federal government, then we have different provinces, and each province has their own regulations and their own healthcare system, and it has to work according with the federal government. If the federal government is telling the provincial government that, okay, your healthcare system is not accordance with our laws, then they have to act according to them. The federal is always superior. Okay, and what do they manage? They manage establishment, maintenance, management of hospital, asylums, charities, license of the physicians, nurses, determining the standard for licensing all hospitals, financing healthcare facilities, medical insurance plans, and certain public health services. Then next, what we have is, this is all the history of the indigenous, history of the Canadian history. So there's nothing as such that is important exam point of view, or they will ask you any question like in which year, what happened. I don't think so. Then this table, it is important. You should know which body is certifying who. Like once we are done with our QE1 exam, previously they had QE2, but now it's no more there. So we are done with our QE1 exam. Who is going to certify us? The MCC. Similarly, the residents who are working in a specific field, specialty. So who certifies them? It's the Royal College of Physicians and Surgeons of Canada. So if someone is completed his residency in family medicine, who is certifying them? It is the Family Physician Canada College. Similarly, we also have the licensing bodies, and each province has their own licensing body. For example, if we are working in Alberta, then we have to get registered with the Alberta's licensing body. If we are working in Ontario, then the Ontario one, and Quebec one. So whichever province we are working in, we have to get licensed by that licensing body also. Then what is CPSO? It is the membership to the provincial license, and it is mandatory for all the physicians to get this. What will they do? They will provide non-transferable license insurance to physicians, maintain ethical, legal, and competency standards, and developing policies to guide physicians, investigate complaints against physicians. So if some physician has been, a complaint has, or legal action has been taken against a physician, so who is going to investigate it? It is this CPSO. They are going to investigate that what happened, what is the legal action has to be taken or no, whether there was any negligence, any harm, anything. So they are going to investigate it. Then discipline physicians guilty of professional misconduct or incompetence. Similarly, then we have these professional associations or bodies who work in different areas. What is the work of the CMA? It provides leadership to physicians and advocates for access of high quality care in Canada, represent physicians and population concerned at the national level. Membership is voluntary. Okay, this is a voluntary membership. Similarly, what is PTMA? Negotiates fees and benefits schedules with provincial government. So they work for the physician. They're working for the physician. So if they need to, any, like in hospitals or any physician, they see somewhere that the physician is not getting enough benefit, then these bodies come in. Then CMPA, physician-run organization that protects the integrity of member physicians, provide legal defense against allegation of malpractice or negligence, provide risk management and educational programs. Membership is again voluntary. Then RDOC or Public Health Office, what do? They uphold economic and professional interest of residents across Canada. So they are working for the residents and the people of Canada, how in collaboration with the physicians, how they can improve the lifestyle of the people in Canada. Then CFMs and FMEQ, medical students are represented at the university. It's for the students working or the residents working in different colleges. It's their bodies for their rights and everything. Similarly, we should know the difference between autonomy, competency, and capacity. What is autonomy? It is the being a patient, the right of the patient to decide whether they want to take a treatment or no, even if it is harmful for the patient. Like if he refuses to take the treatment and it will in long term result in harm for the patient, it is his autonomy. Then like whether he takes it or not. Next is competency. Competency is something that is directed by the court. The court is going to check whether the patient is competent to perform a certain. Now, a patient might be incompetent for some things, but he may be capable to give a consent. So his capacity might be fine, but he might be incompetent. Like a person with some disability, he might be incompetent to perform his daily activities. So that comes under competency. But he's capable to make his own decisions about any disease, about the medications. So this is the difference. So the capacity is the ability to make a specific decision for oneself as determined by the clinicians proposing the specific treatment. So it's not necessary that if a person is incompetent, then he doesn't have the capacity to make his own decisions. Okay. Similarly, then what is beneficence? It is something that the physician has to act in the best interest of the patient. It is the job of the physician that he has to inform the patient about all the adverse effects and the benefits, advantages of any procedure, any medication. And he has to tell him that, okay, this procedure, we have 2 or 3 procedures, but this is the best for you. This is going to be in your best interest. So it is the job of the physician. Then non-maleficence, obligation to avoid causing harm, a limiting principle of beneficence. So what is non-maleficence? That our first priority should be that we are, whatever process, whatever prescription we are not causing any harm to the patient. Okay. Justice, in justice, we have 2 things, equality and equity. So what is equality? Suppose all of us who are resident in Canada, we know that every person in the Canada, they have one healthcare system, whether he is rich, whether he is poor. They are going to take their health card to the hospital, to the physician, and they will be treated in the same way. The same facility is going to be provided to them. So this is equality, that every person, no matter, regardless of their color, of their social background, status, they are provided with the same facilities. But what is equity? Equity is to bring everyone at the same level. For example, we know that people with low income, the government does provide them. We have different schemes like low income houses, then some children grants, some other help for them in dental or in ophthalmology areas. So what is that? That these people, they cannot afford those things. They are low income people, and the government helps them so that they also get the benefit of the things which people with higher status can get. So there's a difference between equality and equity. Then what is the code of ethics? It is prepared by physicians for physicians and applies to physicians, residents, medical students based on fundamental ethical principles of medicine. It's like basically the oath we all take as a, which is called the Hippocratic Oath, that whatever we're going to do, we're going to work in the best interest of our patient and their benefits, and everything comes first. So this is what comes under the code of ethics. Similarly, what is confidentiality? Now, we should know that whenever a patient is, it is a patient and a physician relationship. It's built on trust. So whenever a patient is coming to a physician, the physician has to ensure the patient that whatever we're going to discuss is going to stay confidential between you and me. But we also have to ensure that if there is any legally required, I have to tell it to the appropriate authorities. I will have to break this confidentiality. We can't just promise the patient that, okay, you're coming to us, but we will, no matter what happens, we will never break it. No, that is wrong. So we always have to ensure them that until and unless required by the law, there is any such situation where we have to break this confidentiality, we will break it. Similar, so there are certain criteria which are fulfilled for breaking the confidentiality. And what are those? Those are these. For example, if a patient mother is bringing in her child and we suspect that, okay, it is a case of child abuse or neglect, so we will report. Similarly, if a person is coming to us, a patient is coming to us and he is unfit to drive, we studied in family medicine, like the patient with OSA. So we have to report. Similarly, if the patient has some seizures, some history of some syncopes, so what will we do? We will report to the Ministry of Transportation. We won't say that, no, we have a confidentiality with our patient, we won't be reporting. No, we have to report in these situations. But until and unless he won't be able to drive, until his condition has been improved. Once his condition, for like the patients with seizures, epilepsy, they have a time frame of 6 months to 1 year, depending upon the province. So if they are seizure free for this time period, we have to then again, there's a form and everything, there's a procedure, we do that, and we tell the Ministry of Transportation that, okay, the patient is now good and he has no episodes, so he can drive. Similarly, if the patient has some STI, some communicable disease, like he has tuberculosis, we had COVID previously in the last few years, so we have to inform the public health. Also, if there is some improper conduct of physician or health professional, like if a person is coming to us, a patient is coming to us and he or she is telling us that I visited another physician and their behavior was inappropriate. Either it can be in the form of some sexual abuse, either inappropriate sexual jokes, either the patient felt uncomfortable in any way, then we have to report to the college or the regulatory authority, CMA. We have to report that. We will tell the patient that, okay, now it is our job, because that physician didn't act appropriately, we have to ethically, we have to inform the regulatory authorities now. Okay. Similarly, if there is some death, any pregnant patient, any suspicious death, we have to report the coroner. And who is the coroner? Who is going to further assess into it, and he's going to check whether the death was natural or due to some other cause. So we have to report the coroner in that case also. And if in any of these situations we are not reporting, then the physician is going to be held responsible. And then they have to pay the penalty, and they will be then further trial, then all the procedures can be done. Similarly, if a patient is coming to us and we have our duty to warn or protect, who are we warning? If there any police, we have to inform the police or any informed person. Suppose a psychiatric patient comes to us, and not even psychiatric, if a normal person just comes up to us and he tells us that, doctor, I have planned to kill my wife within a month, and I have made all the required things, and I have done it. So what will we do? We will inform his or her wife. Okay. Similarly, then we will inform the police. But always make sure if they're giving you the scenario, then these three things are met. Is there an imminent risk? Is the danger imminent? Is it going to be happening in the coming future? Then is the person identifiable, or the group, do they know that person? And is it a serious bodily harm? If the person is coming to us and he's saying that, oh, tomorrow I'll just go and I'll slap my wife. So it is not something a bodily harm or something like his death is coming on. So we do not need to report. But if similarly he's coming and he's saying, I'm going to harm, or I'm going to, there's going to be some party and I'm going to kill my brother-in-law, my sister, anyone, then we have to immediately inform the victim and the police. So if they're giving you in the scenario that, okay, the person is coming to you and he said that I'm going to, there's a certain celebrity, the president of America, and I have decided that in next year, I'm going to kill him. It's impossible, right? He doesn't have the resources. He doesn't know the president, and he's talking about after 1 year. So we do not report that. But if he knows the person, he's in the close circle, and the risk is imminent, and it is of bodily harm or death, then we have to report. Then these are the same reasons to breach confidentiality: child abuse, fitness to drive, communicable disease, coroner, and due to warm or harm. So in these cases, we have to breach the confidentiality. We can't say that, okay, the patient was here and it was his confidential matter. We can't breach it. No, because it is something he's going to do. Then lock boxes. What are lock boxes? The term lock boxes applies. For example, if a patient is in a hospital, he is admitted in a hospital. Now, not only one physician is treating that patient. Remember, there are a certain number of other people who are involved in the circle of care. Like there might be another surgeon, there might be another specialist, the nurses come in, there might be some, if it's a teaching hospital, some resident students. So all of these come in the circle of care. If the patient, for example, has HIV, and he says that to the physician, tells the physician that, okay, I do not want rest of all the people in my circle of care to know that I have HIV. So then it is the job of the physician to not disclose, because even if he is being treated for example, he has some surgery, then it won't make any difference if we are informing the surgeon whether the patient has HIV or no. Okay, so these are the, if he says that I do not want certain person in my circle of care to know about this, my history or anything other he has, we cannot disclose it. Then while the patient has a right to access to the, similarly for the medical record, what is the, this is a very important question and you should know this. They can ask in MCQ, they can ask in CDM, that a patient is coming to you and he wants his medical records, or he got tested for some investigations and now he's there and he's saying that, doctor, I need my results or reports in the printed form, or email me, whatever. So the doctor says, the physician says, I'll give it to you, but I will charge you some fees. Like you have to give me $10, $20 for those prints. Although the medical records are the patient's property, but who is holding them? The physician has them. And always remember, the physician can, always, because everybody gets confused, the physician can charge a fees for it. So it is not that we are not going to inform anyone. The patient cannot get angry. It is the right of the physician. He can charge a fees, but it has to be reasonable. It can't be, he can't say that, okay, I'll charge you $500 for your test results, or I'm going to charge you $1,000. No, that is inappropriate. He can charge. It is the choice of the physician whether he charges or not. but it has to be a reasonable fee, and the patient cannot conflict it, or cannot say that, cannot fight with the doctor or be abusive or use inappropriate words. No. Similarly, it is the duty of the physician to secure the records of the patient. Whenever we go to a physician over here, you might have noticed that your family physician, first, there are some other workers, the medical assistants, they come, they take your blood pressure, measure your height and weight and everything. And then when the physician comes, when she uses her desktop, she has that special tag she uses to enter it. So it has, nobody else has that information. So it is the duty of the physician to protect those electronic records. It is her duty. Even the people working in her clinic or office, they cannot access it. So only the physician, when they come, they have their special passwords and everything, and they can, if in the clinic, in somebody else has access your electronic records, your EMR, or your medical records, then the physician will be held liable. He or she will be responsible for that. So always it is their responsibility to keep it confidential. Nobody can access it. Similarly, what is consent and capacity? The consent is like what we are taking from the patient, how they are expressing that, okay, fine, we have, for example, if it can, and consent, remember, it can be in different forms. It's not just a written paper where the patient comes and reads the paper and he has to sign it. It can be informed, it can be voluntary, it can be verbal. For example, if when we go to our physician, very simple example, they are prescribing, we go there for headache, they prescribe us acetaminophen. We take the prescription and we go, right? So in one way, we are consenting to it, that, okay, you have given it to us. We are not signing any paper. We are not saying anything verbally. We are just taking the prescription. We are going to the pharmacy and getting our medicine. So this is also a form of consent. Similarly, if there is some emergency and the patient is coming in, we do not have the time to take a written consent. And the patient says verbally that, okay, doctor, I am ready for the procedure, go with it. Then it is a verbal consent. So if he's capable enough to give it, then just take it verbally and go. So we also consider that as a consent. If there's some procedure that is like elective procedure, and in that case, what do? We take a written consent. So there are different forms of consent. Then always remember that the consent, it should be specific, it should be about the procedure. If we have to amputate the left leg, we will tell the patient, okay, this is the left leg we're going to amputate. What are the long-term risk and benefits of it during the procedure? Who is going to be involved in the procedure? For example, if it's a teaching hospital and students are involved in it, we have to inform him, okay, during the procedure, there will be some students involved in the procedure. If the patient refuses that, no, I do not want any students, I do not want any residents in my procedure, then we will not allow them. If it is a procedure where a time has to be given to the patient, we will give him time. We can't just tell him all the procedures and everything in the morning and tell him to come in the afternoon. We are going to do the surgery, otherwise we're not going to do it. So we have to give him the time to think. But along with it, we have to tell him that if it is a critical case, like if the patient has we have diabetic and he has diabetic foot gangrene, we have to amputate it immediately. We are not going to give him a time of 2-3 months that, okay, you can come after 2-3 months, think for 2-3 months, and then we are going to perform the surgery. No, we have to tell him that time over here is very precious. So this is the time limit. You have 1 week, you have 10 days, you have to think, discuss with your family, whatever you come up with, we are going to act upon it. The final decision is going to be stands with you, but remember that it is time is over here very precious. If we delay it, then what can be the adverse effects? If there is some old patient, always talk to them, the geriatric patient, about if they have some any such condition, talk to them about CPR, DNR. What is DNR? Do not resuscitate. Like if they ever come in a situation in the emergency department where we will have to resuscitate them. So these all things we have to take the consent. Okay, so does he give the consent to us to DNR or no? And remember, if a patient is coming in emergency, we do not have any advanced directives, any SDMs. We do not know his DNRs, whether he had a DNR or no. And he's all alone. And we immediately start the patient on CPR or DNR. It's one and the same thing. We start the patient on that. We have just started. We have put the patient on ventilator, or we were doing the CPR, and a family member comes in and he said he never wanted that. So what are we going to do? We're going to stop over there. We are not going to continue it or keep the patient ventilated that, on the ventilator that, now we have done it and nothing can be done. If we have started a procedure and in between the procedure, someone comes or we find any patient who will about it, any SDM comes, anything, and they say that he never wanted it, or this was not his will, was not to be get DNR, then we have to stop it. We have to remove it. Okay. Similarly, if the patient is coming and we have, just remember this chart for the consent, then it's going to be easy. Is this a treatment? If it is not a treatment, just some other procedure or some other confusion, then we have to use the common law, whatever it states. Similarly, if it is a treatment, now if it is a treatment, we have to see whether it is an emergency situation or a non-emergency situation. If it is an emergency situation, and is the patient able to give the consent? Okay, he is able to give the consent. It's a treatment. We will take the consent from the patient. But if it is not an emergency situation and the patient still at that time is not able to give a consent, non-emergent patient situation, patient is not able to give the consent, then we will wait. Okay. But if it's an emergency and there is not able to give the consent, no STM, then what will we do? The physician is gonna work according to what is best for the patient. Okay, and we are gonna proceed to it. Similarly, if we need to get a review from the review board or the hospital ethics committee, we will go for it. If there is a SDM available, then is the SDM capable of making the decision, and is the SDM making the decision in the best right of the patient, in the best interest of the patient? If the physician at any time sees that the SDM is making the decision which is not in the best interest of the patient, then the physician can always challenge it. Okay, he can always challenge the SDM. Remember that. And does the SDM consent? If yes, treat. If no, do not treat. Similarly, for Jehovah's Witness, what do we have to do if they're coming in the emergency? They have a card. Then even if the patient is dying and they have a valid card, we will not transfuse blood to them or any blood-related products. But for Jehovah's Witness, always remember that the children are not including in it. For example, there's a road traffic accident and they brought in a dad and a son. Okay, and the mother comes in and she says that we are Jehovah's Witness, and you find the card in the dad's wallet. And now she says that do not treat the child also, do not give him blood. But the child, he needs blood. It's an emergency situation. In that case, we will transfuse the blood to the child. We won't transfuse the blood to the dad, but we will transfuse it to the child. Similarly, if somebody has a Jehovah's Witness card, all of these things, the Jehovah's Witness card, if they have any DNR written, they have an expiry date. And it has to be like we get our driving license or anything, we have to update it regularly. After the expiry date, it is invalid. So if a person is coming to us and in the emergency, nobody's there, and we see that he has a Jehovah's card in his wallet, which was expired 1 year ago. Now he did not renew it. So what will we do? We will transfuse the blood. Okay, because according to the card, it has been expired. Maybe his wishes changed and we do not know. Because if it is expired, then he should have gotten it renewed. So he did not got it renewed, then we will transfuse him blood. These are all the same things. Then in the emergency, we will take without, if it's a life-threatening condition, we don't need consent. We'll just proceed with whatever is the best for the patient. Then in special situations, like if there is some psychiatric patient, the patient is psychotic, the patient is suicidal. In that case, we do not need to take the consent. We involuntarily admit them. Similarly, if the patient is refusing for treatment of something, simple example of COVID. We had COVID in the last years. And patient, what happened? Like there was a screening process. It was a communicable disease. So if a patient is coming to us and we are saying that he has COVID, he says that I don't want to be treated, what will we do? We will treat him, because we can't just let him go and spread it to all the other people, putting their life at risk. Similarly, for tuberculosis, if a person has tuberculosis, we have to treat him. We have to isolate him. We can't just say that, okay, the patient is refusing to take the medications, we cannot treat him, it's against his consent. No, we have to treat him because he's putting others people's life at risk. Okay. So yeah, special public health emergencies like an epidemic, communicable treatment, warrant to information by the police. Now, when are we informing the police? Only if the police is bringing a warrant. Remember, if the police is coming in and they are telling us that this and this patient, we suspect that he murdered someone, or this or this patient, we suspect that he is a drug dealer, you need to take a proper physical examination of this patient. If the police doesn't have any warrant, we cannot conduct any physical examination on the patient. We cannot tell them about any medical information of the patient. Okay, for example, police brings in a patient in the emergency department in the hospital, and he's alcoholic. He had some accident. Now the police wants us to perform a proper examination and everything, and ask him all the things. We will not do that. We will ask the patient, we'll tell him, okay, the police is here, they are suspecting this, and do you want the physical examination to be performed? Do you want these tests to be done? If the patient refuses, we cannot do anything. Okay, we will tell the police that go bring a warrant or a court order. But if they're coming with a warrant and a court order, then we have to do it. Okay. Similarly, if a insurance company has approached us for the patient's health information, we will only provide the specific information they are asking. Mostly the insurance companies, what they want the recent information of the patient for the recent test done. So we have to provide them with the recent information with the consent of the patient, but we cannot lie. For example, if the patient has dyslipidemia, or he has diabetes, and he says that, please, in my insurance form, say that I do not have it. We cannot do that. Okay. If he previously had hepatitis, if he previously had some other such disease, for example, he's even a patient of HIV, and the insurance company hasn't asked us the information, then we will not provide them with that information. What is a battery? Battery is the treatment without consent. Okay, remember, we are treating the patient without his consent. Where we could have taken his consent, then this is battery. And the patient can always hold the physician reliable that I had the capacity to give the consent. But if the physician thinks that the patient is not reliable to give the consent, okay, then the patient can always hold the physician reliable, and he can always go in the court against the physician if he thinks. Then proper legal process is going to be done and it's going to be assessed. Similarly, now what is capacity? A capacity is the mental status of the patient, whether he can assess his illness, whether he can assess the drugs we are giving him, about the treatment process. Does he has the capacity to assess it or no? Who is going to assess it? The physician. But after the physician, the attending physician says that, okay, the patient doesn't have the capacity, then there is a proper team. There's a consent and capacity board, which includes some special mental health nurses, physicians who are again going to reassess it. Not on the basis of the attending physician, he comes and he says that, like, I am the physician and I just tell that this patient doesn't have the capacity. No. Then there are some other there's a committee which sits and they assess whether really this patient has the capacity for certain disease or things or no. Okay. For the appreciation needed for decision-making capacity, a person must acknowledge the symptoms that affect them, be able to assess how the various options would affect them, be able to reach a decision and make a choice not based primarily upon delusional belief. And always remember, it is not necessary that the patient has a psychiatric illness and he or she is also incapable of making his decisions about his treatment. No, okay. They usually do ask this question that patient with schizophrenia, he's here in the clinic and he refuses to take certain medications. And he is capable for it. He has the capacity. So what will we do? Will we act according? We will not give him the medications. We will admit him. What? Because capacity is something else and psychiatric illness is something else. So a patient can have schizophrenia, but his capacity can be perfectly fine. Okay. Okay, then what do we have? Then we have this power of attorney. Okay. And it is mostly done by some incapable people or people who are like old people, geriatric population. For them, we assign the power of attorney. There are different types of power of attorneys now, okay? Power of attorney for personal care, a legal document in which one person gives another the authority to make personal care decisions. That is healthcare, nutrition, shelter, clothing, hygiene, and safety on their behalf if they become mentally incapable. A person is giving authority to some other person that whenever they become mentally incapable, they will cater all these things for them. Till the time the patient is capable to make his own decisions, he can. It's not like just one time he has done it and it cannot be changed. No, it can be changed whenever he wants to change, until unless he's capable. Okay. Secondly, till the time he is capable of doing all these things, he's going to do it himself. The person he has assigned as his attorney, he can't just come in that, okay, he has signed the paper, now I'll do all these things. No. The guardian of the person, the court appoints him. And what he does, he makes decisions on behalf of an incapable person in some or all areas of professional care. Similarly, continuing power of attorney for property. It was also done by the court, or the person can also assign it themselves. Okay, so who is this person? He's going to look into the legal matters of the patient, like financial issues. All the financial things are going to be done by this person who is assigned for the property. Then there can be a person who's guardian for the property. And it can be appointed by the public, or the public guardian, or the trustee, or the court. Anyone can assign them as being the guardian of the property, just to check that nobody is taking advantage of the person's finances. Public guardian and trustee acts as SDM of last resort on behalf of mentally incapable people who do not have another individual to act on their behalf. Then what is for the pediatrics? Remember, there is no age of consent. If there's a 10-year-old child and he refuses for the treatment, he understands all the risks and benefits, and he says, I do not want the treatment. The physician thinks that the treatment is in the best interest of the patient. The parents say it is, but if he's refusing, we will not treat. Okay, so there is no, in Canada, there is no age of consent. So remember that, because in the US, there is. If the child is refusing, we will go with what the parents say and the physicians say. But here, no. For example, if the patient is of leukemia, the child has leukemia and he understands all the risks and benefits and everything, and he says that I am sick and tired of getting these blood transfusions or all the tests done, and I don't want to continue it, then we will respect his choice. Okay. But it all matters if he's capable enough, if he's understanding the procedure. Similarly, then what we have, and remember, if there's another term known as assent. What is assent? That if a person is incapable, he doesn't have the capacity to make his own decisions, even then, if we are going to perform any medical procedure on the patient, if we are giving him any medications, we have to tell him or her. Okay, we have to inform them. They are not being the part of the decision making. For example, a patient with Alzheimer's or Parkinson's at very late age, they cannot make their own decisions. We have to give them some shot, for example, flu shot. Before giving the flu shot, we will inform that okay, Mr. This and that, we are going to give you the flu shot, and these are the risks and the benefits of it. And then telling him, like, we're going to do it over here, how are we going to do the procedure? That is known as assent, even though he doesn't understand it. He won't be, but we have to inform them. Then what comes is negligence. If there is any negligence on the behalf of the physician, then it has to be reported, and the physician and the patient can report it, and all the proceedings are going to be done, and it's a legal process that goes on. But what if any negligence is done and the patient is not harmed, but that negligence or that thing reached the patient? Even then we have to inform the patient. Okay, like simple example, patient is in the hospital and the patient is admitted. He is allergic to penicillin. What we do, we write the report, and we don't check his medical records. We prescribe penicillin. Penicillin was given to the patient, but fortunately, there was no reaction. The patient was fine. Now, later on, it came into our knowledge that the patient had allergy to penicillin. Although he didn't have any reaction, but still we will go to the patient and we will tell him that, okay, Mr. This and that, we as a team made a mistake and we take responsibility for it, but thank God nothing bad happened. Similarly, if by any chance he did had a reaction, then a harm has to be done. Even then we will tell the patient and we will report it also. So for both the cases, if the harm is done, if the harm is not done, we have to tell the patient and report it also. But if we had prescribed the patient the medication, the penicillin, but before injecting the penicillin, the nurse, she by any chance, or we by any chance, checked the reports and his previous records, and we saw that, oh, he's allergic, and we immediately cancel our orders. He was not given penicillin. So what is this? This is something that has not reached the patient. It is near harm. So we do not need to report it. We do not need to inform the patient. But once a thing has entered the patient's body, something has happened, but whether it had a reaction or no, we have to inform it, and we also have to report it. And remember that we are not going to just put the burden on, because in these cases they might give you that the patient is very angry and he's asking that whose fault is it, and I'm going to sue you, I'm going to do this and that, even though the patient didn't have any harm. We are not going to tell them that this nurse was responsible for it or this physician was responsible. No, we have to take the responsibility as a whole, and we have to tell the patient that we are sorry, but we do not know. Still, the process is under investigation, and we cannot tell you the name of one person who, because of whom this harm was done. Okay, we can't just put the burden on any one person. We can't just tell that, okay, this nurse, she did it, or this doctor, physician, he wrote the orders, he gave the orders. No. So we always have to tell them that being a doctor, being a whole team, we are working as a team. We will investigate it. We know you are angry, but right now we cannot take name of any one person. Okay. Then what is truth telling? Always tell the patient the truth. We do not have, like, if we are suspecting that, okay, the patient, for example, patient wants to, a female patient, she wants to get abortion done. So we can't just scare her so much because our beliefs that, no, this is this and that. We have to tell them all the, we can counsel them. We can give them different options. Okay, I know you want to, first we have to ask them why you want to get it done. Then what are the other options she have? She can go for some foster care, some adoption of the baby later on, some other social support. But still, if the patient wants that, no, I want to go for the abortion, we will help her in that. And if at any point we think that the patient, what the patient wants is against our ethical beliefs or our cultural beliefs and norms, what we can do, we cannot just tell the patient, no, this is wrong and I will not do it. We can refer the patient to another physician. And during this time, while referring the patient to another physician and getting the appointment done, if at any time the patient needs any care, we have to be there to check the patient. We can't just tell that, no, we have referred you to another physician, now you're out of my care, I cannot do anything. So we have to also look into this. We can't just leave the patient abandoned. Then we have, for this breaking the bad news, just remember this is more important for a NACOSCI point of view, okay? That how we are going to break the bad news, and in NAC, they do give you scenarios for this. So you should know this spikes protocol. There should be a special setting. The perceptions should be met. Invitation, if the person wants anyone else to be with them, any knowledge they have about the disease, what we're going to tell them, show them some empathy, and what strategies we're going to use. So it's more important for that. But just remember these spikes, what spikes stand for, and how we break the bad news. Similarly, if the when we are not going to tell the patient the truth about his disease, first of all, whenever we have to break any news to the patient, we have to ask them, okay, how much information do you want to know? If the patient themselves says that, okay, I do not want to know this and this information, doctor, we will not disclose it. If the patient, so a patient has cancer, and we go up to them and we tell that, okay, we have got your results, and now you tell me that how much information you want. The patient says, I do not want any information. Just tell it to my wife, just tell it to my kids, and you just treat me. I don't want, because there are some cultural things we always have to keep in mind. In some cultures, the patient doesn't know anything and the family members do, right? So we have to always respect that. If the patient says that, no, I do not want this information, you can share it with my family, we will treat the patient accordingly. We will not give him the information. But if the family members are coming to us, we are going to tell the patient something, and the family members come in and they say that, please don't give this information to my parent or any wife, husband, then we have to inquire more about it. We have to ask them that why you don't want this information to be given to them. Okay, and we have to tell them that it is the patient's right. And without this, his right, we cannot hide this information for him. So we can ask him how much information does he want. If he agrees to it, if he consents to it, then we will act accordingly. Similarly, in some cases, if the patient knows or the family members tells, or according to his previous history, we get to know that, okay, the patient, if we tell him this, his reaction is going to be really bad, or he won't be able to take the news, then we can hold the truth for some time, okay? And we can slowly prepare the patient, and tell him the news. Or if we see that, okay, at any point, if we tell him, it can have a very bad physical effect on the patient, then we can withdraw it. But there are very special circumstances in which we have to do it. Yes, so we will refer him. And also, when can we refer a patient? When, for example, everything is fine, but what if the patient, he is being abusive with the doctor? Then the doctor can stop his care for the patient. Okay, he can tell him that abusive is not allowed and I will not tolerate this behavior. And he can tell them, he can refer him to another physician. Similarly, if the patient, you are prescribing the patient some medications and what you found out that he has been selling those medications, so it is an unethical behavior. In these cases, what can the physician do? He can refer the patient to another physician. Or if you are trying to treat a patient and the patient is not convinced with your approach, he thinks that you are not treating him properly, then you can politely tell him that, okay, I've tried my best, but as you are not convinced, we can refer you to another physician, and he can stop taking them as a patient. But remember, in these three situations, always till the patient finds another physician, or you can just tell him that, okay, I'll not be taking you anymore. You have to find another physician for yourself. And till the time the patient finds another physician, what our duty will be, if there's any emergency, any situation comes out, we have to treat the patient. Okay. Then the pregnant woman. The pregnant woman, remember, always it is the health of the mother that comes first. And until and unless the baby is born, he has no rights. And all the rights of the fetus are with the mother. The father, the grandparents, the siblings, nobody has any right to interfere with what the pregnant lady has taken the decision. Okay, if she says, I do not want to carry this baby, we cannot, the father can't just come in and say that, no, he's my child also. No, if she says she doesn't want to carry it, we will go with her wishes. Okay, if she says before the delivery that I don't want a cesarean section, though cesarean section is best for the baby, and if we deliver it vaginally, the baby can die, we will go with the vaginal delivery. But the moment the baby is born, like comes out of the mother's belly, 1 minute, like even a few seconds, now he or she has his own individuality. Now the mother cannot say that, okay, I do not want to do this, I do not want to do that with the baby. No, now we will act what is in the best interest of the baby. For example, if the mother has tuberculosis or mother has some HIV, and during her pregnancy, she didn't want to get treated for it. We want, for tuberculosis, of course, we have to treat, but like HIV or hepatitis. And then she says that I don't want to get it treated. We won't treat her. We won't conduct any tests. But after the delivery of the baby, now the mother is saying, I want to feed the baby. What will we do? We will not let her feed the baby, because it is a contraindication, and now the baby has his own rights. We will do what is in the best interest of the baby. Okay, yeah, this is all covered. Then the Royal Commission on New Reproductive Technologies recommendation: medical treatment must never be imposed upon a competent pregnant woman against, same what I just told you. Like if she doesn't want to go to things, we cannot. Like similarly, if the mother is smoker, right? And yes, she's a smoker, and during pregnancy, we counseled her everything. She said, no, I will smoke. We cannot do anything. But after the baby is born, she now says, I will smoke in front of the baby, or I'll smoke with the baby. Then we have to act in the best interest of, and we will inform CAS. We will remove the baby from the mother. No law should be used to confine a pregnant woman in the interest of her fetus. The conduct of a pregnant woman in relation to her fetus should not be criminalized. Then the child welfare should never be used to control a woman's behavior during pregnancy. All of these things are happening during pregnancy, remember. Civil liability should never be imposed upon a woman for harm done to her fetus during pregnancy. Examples involving the use of established guidelines. A person is permitted to refuse HIV testing during pregnancy, even if vertical transmission to the fetus results. However, once the baby is born, breastfeeding and even theoretical transmission of HIV may attract criminal liability. A person is permitted to refuse cesarean delivery in labor that is not progressing, despite evidence of fetal distress. Okay. Similarly, for the potential use of stem cell in research, when we can use it, studying human development and factors that direct cell specialization, evaluating drugs for efficacy and safety in human models, cell therapy using stem cell grown in vitro to repair or replace degenerated, destroyed, or malignant tissues, genetic treatment aimed at altering somatic cells is acceptable and ongoing. Remember, there is no age of abortion. Okay, like if a pregnant woman is coming for termination of pregnancy, there's no age. She's coming at 30 weeks, at 32 weeks. She's saying, I don't want to carry this baby anymore. If she's capable, everything is fine. We have checked, then we will go with her wishes. But it is our duty, of course, to counsel her, first to ask what is the reason, then to further give her different options. If still she is saying no, then we have to proceed with her wishes. Also remember that as the fetus has no rights, right? So if during pregnancy, what happens that, during delivery, due to any negligence, any cause, the baby dies, the fetus dies, or during this whole time period, any inappropriate treatment is given, or the treatment is not, the disease is not identified and fetus dies, the doctors won't be held reliable. It will not be taken as a case of negligence because the fetus doesn't have any rights, right? So, but once the baby is born, and now if anything wrong goes with the baby, any negligence is done, CAS has to be informed. The doctors can be held responsible if anything did happen on their behalf. Okay. Then we have this end of life care. In this, we have two things: euthanasia and medical assistance in dying. So what is euthanasia? Euthanasia is knowingly and intentionally performing an act with or without consent that is explicitly intended to end another person's life where that person has an incurable disease. And MAID, the medical assistant in dying, administering or prescribing the self-administration by a medical practitioner or nurse of a substance that at the request of a person that causes their death. First of all, remember that in palliative care, our aim is always to maximize the quality of the life of the patient, to relieve his symptoms. Our aim is never to increase the life. Okay, we just have to relieve the symptoms of the patient. The life he is left with 6 months, 3 months, we just have to make easier for him. For example, if the patient has some chronic pain and we are giving him opioids for it, and at the dose we are giving him, his pain is not getting relieved, and he asks for a higher dose, and we know that the higher we increase the dose, he can go in respiratory distress, he can die. But our aim will be to increase the dose. If the patient is not getting relieved with that specific, if we have to increase double the dose, triple the dose, we will do it. We won't be saying that, no, if we increase the dose, the person can go in respiratory distress, he can die. No, he's already dying. He has to die. So in palliative care, our aim is to just improve the quality of life, not to prolong it. Similarly, for MAID, there is a specific criteria which the person, if they fulfill, then MAID can be done. Then it is legally allowed. If the person does not fulfill that criteria, we cannot proceed to MAID. Okay. And what are those criteria? Yes, it is this. That, where was it? Yes, here it is. Sorry. The patient is eligible for public, and remember, for MAID, if they're going, it is a publicly funded, the government funds it. Okay. At least 18 years of age, has the capacity for clear and freely given consent. An incapable person who does not have the capacity to give a consent cannot undergo MAID. Only the person who has the capacity to give the MAID, like who understands his condition, he knows that, okay, I'm going to die or his disease is incurable, only that person can go into undergo MAID. An SDM cannot bring a person and tell the doctor that it's very hard for us to take care of him, the person is going to die in 2-3 months, so please go for MAID. No, the person has to be capable enough, give the consent, has the capacity, at least 18 years of age, the disease he has is an incurable disease, has a lot of effect on his daily lives, and he sees that, okay, in the near future, in 6 months, 5 months, he's going to die. So then we have to fulfill this criteria. Then he fulfills the criteria for MAID. Also, whenever going for the MAID, we have to see that 2 independent witnesses are signing the request. So those witnesses cannot be someone associated with the MAID healthcare facility, the supervisor, it can't be them. It can't be the physician of the patient who is treating them. It can't be any other person who has some financial benefits from the patient. So these people cannot be their witnesses. So it has to be someone else. And once the patient is, everything is done and he agrees for MAID, at any time before MAID, if he withdraws his consent, he can withdraw it. Even like a day before, an hour before, a second before, he can always withdraw his consent. Then 2 independent assessors must provide written confirmation that eligibility criteria is met. Similarly, for the MAID, at least the minimum time period the patient is given is 90 days. Okay, so once he makes the request, all the eligibility criteria is done, then within 90 days, he is going to be the process of MAID is going to be done. But if we see that it is something very intolerable, or the time frame is very less, then we can also take 10 days. Okay, throughout the 10 or 90-day period and immediately before providing MAID, the healthcare provider must give the individual an opportunity to withdraw the request and ensure that the patient gives express consent to receive MAID. Similarly, so like any time before it, we have to ask him again, and we have to give him the opportunity that, okay, you have this chance, you want to withdraw, you can withdraw. Now, when do we notify a coroner, or who is a coroner? Coroner is a person who deals or looks into deaths which occur due to any uncertain condition, like a pregnant woman coming to the hospital with some bruises here and there in the body, and then after some time she dies during delivery. What will we do? Even if she doesn't have any bruises, right? But she dies during delivery, what will we do? We won't just make a death certificate and give her to the family. No. As a physician, we have to inform the coroner. The coroner will investigate it, and then further process is going to take place. So notify coroner if death occurs due to violence, negligence, misconduct, pregnancy, sudden or unexpected causes, disease not treated, cause other than disease, suspicious circumstances, and MAID. And it is not the job of the coroner to tell that, okay, this He just has to do some medical legal proceedings. He will just notify, make a legal proceeding and say that, okay, whether it was a natural death or unnatural death. Simple. It's not his job to find who was the cause of the death, or he doesn't have to investigate it. Okay, he doesn't have to reach to the main criminal, you can say. So he just has to investigate, and he just has to tell whether it was a natural or unnatural death. Coroner investigates these deaths as well as deaths that occur in psychiatric institutions, jails, foster homes, nursing homes, hospitals to which a person was transferred from a facility, institution, or home. In consultation with forensic pathologists, the coroner establishes the identity of the disease, where and when the death occurred, the medical cause of the death, the means of death, natural, accidental, suicide, homicide, etc. Coroners do not make decisions regarding criminality or legal responsibility. They cannot tell that, okay, the husband is the criminal or the neighbor is the criminal. Their job is just to tell what was the means of the death. And if a physician at any point he doesn't report to the coroner in any of these cases, then he can be held reliable, and he will be held reliable. Okay. A legal action can be taken against him. Then what we have is the professional conduct. Always remember that a doctor and a patient, they can never have any sort of relationship. If a time period of 1 year has passed since the patient was under the care of the physician, after that they can have a relationship. But before that, they cannot have any relationship. And for psychiatric patients, for lifetime, they can never have a relationship. Okay. For normal physicians, they have a 1 year time period. Okay. Since the last therapeutic contact, 1 year has passed. After that, they can have personal relationship. But for a psychiatric patient who had some psychotherapy done, for example, for some psychiatrist or other physicians, they can never, for life, they cannot have any such relationship, personal relationships. And the records of the patient, they will be held for at least 10 years. So for 10 years, the records of the patient are held with the physician. After 10 years, they are destroyed in an appropriate way. Previously, they were burnt or some other ways, but now as we have the EMRs, so they are destroyed or deleted in the way where they cannot be in some softwares, we do have the option like we delete it and then we can bring the files back. But in this case, we do not have these options. Once deleted for life. They cannot be brought back. Although the medical record is the property of the physician or an institution, the following is true. The patient or the patient's delegate must be allowed full access to information in the medical record. The patient or the delegate must obtain access within a reasonable period of time, usually upon a written request. The physician can charge a reasonable fee. In hospital, physicians must ensure their own competence, respect hospital bylaws and regulations, practice only within the limitation of the granted privileges, cooperate with other hospital personnel, and maintain adequate hospital records. Similarly, if we made a patient record, we noted something in our records, and then the patient comes, or if he's checking his records and he says that this thing is wrong, or in my history, it was not like this, it was something else. We will not erase that. Okay. What we will do is that, please mute yourself. What we will do, we will just make a cross and we will put a note along with it. Okay, and add the new history or any treatment, whatever it was. We cannot delete what has been written in the medical records. Then for the research, it is like, it should be if we are conducting, taking some people or the participants in the for research purpose, they should be informed about the research, how long it is going to be, what are the benefits, what is the research about, and if they want to withdraw, they can withdraw at any time. So it's all about the research ethics. Then what about the physician? And remember that a physician is never allowed to take anything from the patient. Even as a gift of thank you, treated the physician treated you, and then you bring in some, even a flower, that is not allowed. Okay, for example, they can give you a question, you go into your room and over there you find a bouquet. You will not just get really happy, oh, my patient, he brought me a bouquet of flowers. No, we have to ask the patient, and we have to tell him first. We will inquire the patient. We'll ask what will be the next step be. We will, if the patient is in the room, ask him there and then. If not, come out of the room, ask the patient that why did you bring it? What is the reason behind it? Okay, whatever reason he's giving, he or she, then tell them politely that we cannot accept it. I, as a physician, it is against my ethical duty. I cannot accept any sort of gift. So we have to tell them in a polite way, and we have to refuse it. Similarly, if the pharmaceutical industry, they are giving you any like sometimes if we go it's common in Asian countries that even the whole clinic is, your office, it would be full of those pharmaceutical clocks and banners, and the fan is also from the table, is from them, the pen is from them. So we cannot over here, we cannot take any of these things, okay? Because what they say that it can impact the way a physician treats the patient. Okay, because if a pharmaceutical company is giving us something, then unconsciously or in our subconscious, it does influence us some way, one or the other, and can influence our practices also. So no such thing has to be accepted. Also, if there is any conference going on and they ask us to attend the conference, only if we are presenting at the conference, then we can accept the travel fee and the accommodation fee and everything. But when we are at the conference and we are presenting over there, we have to inform them during our presentation or written thing, whatever, that this pharmaceutical company, they provided me with all these things. My sponsorship was done by them. Okay. And then we can move on with our presentation. But at any time in the presentation, we have to inform the attendees that we were sponsored by them. And even after attending the conference, our behavior towards our patient, and we should always ensure them, okay, you are going to sponsor me for all these things. I'm going to present there, but it will not impact my clinical judgment or how I have to treat my patient. I will not be obliged to prescribe your medication or your equipments to my patient. So we always have to ensure them. Physician receiving such sponsorships must disclose this at the presentation or in a written article. It is important to note, however, that the disclosure of conflict does not eliminate the potential influence that the conflict may have on physician behavior. Then we know that it is the patient's choice and his autonomy that he can refuse a treatment. If he's refusing, we have to go with him. But on the other hand, we do not have to be biased towards the patient. We do not have to judge them on the basis of their appearance, on the basis of their color, on the basis of their beliefs. We have to stay neutral. We can't just judge a patient coming into us. For example, if a homeless person is coming to us, and we can't just judge them that, okay, he's homeless, he definitely has an STI. That is why he's here. He is homeless. He definitely is alcoholic. So on their appearance, we cannot judge them. Similarly, on the basis of their disease, on the basis of their religion, their beliefs, we cannot tell them that we will not treat you. We cannot discriminate them. Okay, if a patient is coming to us and he has some incurable disease, we are not going to tell them that you're already going to die, we are not going to treat you. A woman is coming for abortion, we, leaving our beliefs aside, we cannot judge them that why does you want to get the abortion done, it's unethical, it's this and that. No, we have to keep all these things aside and treat the patient as a patient and just whatever is in the best interest of the patient. Similarly, if the patient has some, here the indigenous population, they do have some beliefs about some spiritual healing, about some natural ways of healing, homeopathic, all these. So we have to take those things also into consideration. We have to move along with their beliefs. We just can't tell them bluntly, or if we don't believe in any such thing, that no, your beliefs are wrong and you're living in this 2023 and this is all wrong. And no, we have to move with the patient. We have to take their beliefs and counsel them in a proper way. And if they want to go with their beliefs and the treatment together, we will move according to that. That's it. This is the end of your ethics. Yeah, and one more thing I wanted to share is, just let me open. You should know all these. Sorry. Yes, in preventive health. Sometimes what we do is we miss this page. So you should know, when are we reporting? It's just a journal, we just did it over there. When are we reporting? The physician has to report live births, stillbirths, deaths to the coroner or the registrar, sorry. If there's a live birth certificate, and then you have to register it. Similarly, if there's a stillbirth or there's an inappropriate death, go to the coroner. If the death is proper, natural, have to make a death certificate. All live and stillbirths must be reported within 2 business days. A physician with sufficient familiarity of a patient's illness or who was in attendance of a diseased patient's last illness must complete and sign the medical certificate of death. Physicians must contact a coroner or the police if the patient is suspected to have deceased from violence, misadventure, negligence, the same we just studied, just went through. So all of these we have to inform to the coroner. Child abuse or neglect. It's not just abuse. Even if you're suspecting a neglect, you have to report to the CAS. Similarly, if there is some gunshot wound or a stab wound, like a knife wound, even if the patient is coming to you and he's saying that do not report it to the police, we have to report it to the police until and unless it is a self-inflicted knife wounds. A person coming with a self-inflicted knife wound, he tried to harm himself, we will not report. But if he was in a street fight, if he was in any pub, any cafe, and over there was a fight, there was a gunshot, or he was stabbed by another person, we have to report, even though the patient says, please don't report it. Then what we studied, that elderly abuse, we do not report it, right? Until and unless the patient gives the consent for it. But if they are living in long-term care facilities, in retirement homes, and there is an elderly and we suspect that there is a neglect going on, there is an abuse going on, we have to report it. Who will be reported to? To the registrar of the Retirement Home Regulatory Authority or Long-Term Care Home Director. Okay. Similarly, for unfit to drive, we have to report to Ministry of Ophthalmology. The patient might have epilepsy, the patient might have episodes of syncope. Okay, he recently might have undergone MI. So any might have some, may have some vision problems, dementia. So we have to report in all these conditions. Unable to fit to drive, report to the Ministry of Transportation, the Aviation Ministry. Okay, so you should know these table also. So we are done with our ethics. If you have any questions, you can ask.